not reflect the views of the United Nations. So this is always requested from the United Nations headquarters whenever UN judge have such opportunity like this. And now I'd like to start my presentation. So further to the presentation of the professor, I'd like to focus on the international judicial framework. International judicial framework for the protection of women and children's rights. We can think about two kinds of international tribunals. One is International Criminal Tribunal, a little mentioned by Professor. International Criminal Tribunal seeking individual criminal responsibility. And the other is International Human Rights Tribunal seeking state responsibility. Unlike national justice system, the scope of international crime is very much limited and very much difficult to prove. For example, the rape. Rape as national crime does not require other elements of crime, but rape itself. The prosecutors can have only to prove the rape itself. But rape as international crime, as just mentioned by Professor, as you know, this is part of crime against humanity. So rape as international crime requires additional element of crime that the rape was committed as a part of widespread or systematic attack directed against any civilian population, which is very much difficult to prove. So for the protection of efficient protection of the women and children's rights through the international judicial framework, we always need to think about not only the International Criminal Tribunal seeking individual criminal responsibility, but also International Human Rights Tribunal seeking state responsibility. So I'd like to briefly introduce you the established international criminal tribunals and its procedures for the protection of the women and children's rights. And then I will propose some practical consideration for the establishment of Asian Court of Human Rights as International Human Rights Tribunal. Starting in the early 90s, a small number of UN-backed international criminal tribunals have been established, as you know well. If you look at the UN website on human rights, you can find five names. ICTY for former Yugo, ICTR for Rwanda, SCSL for Sierra Leone, ECCC for Cambodia, and STL for Lebanon. But Lebanon court, STL, even it was organized internationally, is dealing with only national crimes, not international crimes. So the other four are international criminal tribunals. So organized internationally, dealing with international crimes, applying international standards of criminal procedure. So the first one is ICTY for former Yugo. It was established by the resolution of UN Security Council and dealing with international crimes. Such as war crimes, crimes against humanity, and genocide. This is the first UN-backed international criminal tribunal. And second one is ICTR. It's almost same with ICTY, same international crimes, and also established by the resolution of the UN Security Council. But Sierra Leone has a little different story. It's also dealing with the same international crime, but it was established. There was a resolution as well, but it was established by the agreement between the United Nations and national government of Sierra Leone. And through the negotiation, the Sierra Leone could have the power to be involved in the court procedure. So Sierra Leone judges, prosecutors, lawyers are working with the UN court. This is the first mixed court or hybrid court. And next one is ECCC, where I'm working for now. So this is almost same with Sierra Leone. There was a resolution, but the decisive procedure was also agreement between the United Nations and Cambodia government, and having the same international crimes. The Cambodia ECCC, the Cambodian side is more involved than the Sierra Leone. So, for example, Sierra Leone have two prosecutors, but one UN prosecutor, the other Sierra Leone deputy prosecutor. But ECCC, one UN prosecutor and one Cambodian prosecutor, but they have the same power and they should work jointly. And for Chamber, Sierra Leone, two UN judges and one Sierra Leone judge. But ECCC, two UN judges, but three Cambodian judges. The majority is on Cambodian side. So UN had to develop some unique systems for the ECCC to keep the ECCC proceed and in accordance with the international standards. So for the prosecutors, we have, because they are supposed to work jointly, but they cannot always reach agreement. They sometimes do not agree each other. So we have disagreement settlement system to keep the court proceed in spite of their disagreement. And for the chamber, we have very unique majority system. We call it supermajority. So not 3 out of 5. We need 4 out of 5 to reach agreement, to make decisions among the chambers. So these systems make the ECCC to proceed in accordance with international standards. So if you look at, maybe you may have read many articles regarding the ECCC, usually criticizing the disagreement between the UN side and Cambodian side. But if you have another chance to read such article, then just disregard it. As I mentioned, disagreement is not the problem at all. Disagreement between UN and Cambodia is part of our ECCC procedure. So that could be handled by the pre-trial chamber, where I belong to. So disagreement is no problem at all. It's the part of procedure, and that can be handled our system of the ECCC. So that is the ECCC. And these four are what we call special court, because they are established on ad hoc basis and supposed to be closed if their mission is completed. But ICC is permanent international court, and have engaged in prosecuting cases since 2002. So now the cases, new international crimes committed after the 2002, in principle are supposed to be handled by ICC. But I don't want ICC should remain permanently. I hope someday ICC also be closed, because there is no any more international crime in the world. So ICC have nothing to do. So I hope ICC also could be closed. They should not remain as permanent court for the peace of the world. But it's permanent court. So also dealing with the international crimes. So these international crimes have engaged in dealing with international crimes, including any crimes against women and children. And in the procedure of the international crimes, the major role of a victim is to participate, is to appear before the court as witness, as you know, witness. Victims are usually play the role as witness during the procedure. Especially in international criminal procedure, due to lack of such documentary evidence left behind the commitment of international crimes, the witness testimony, the victim testimony, is the primary source of evidence. But the problem is that most of the sexual crimes are committed between just perpetrator and victim, without any eyewitnesses, just between perpetrators and victims. So, as a result, the victim's written statement or victim's testimony is only evidence in most of the sexual crimes. So the victims are really many times requested to appear before investigators, prosecutors, and also chambers. And this may sometimes often cause re-traumatization of those victims. That's why most of the national and international tribunals have developed protective measures for the victims, witnesses, especially women and children. So all these international tribunals also have developed protective measures, ICTY, ICTR, SCSA, ECCC, ICC. They all have developed protective measures to protect witness, victim, especially women and children. Furthermore, ICC is the first court to allow victims to participate more than as witness. They can some more extra role during the procedure, criminal procedure. ICC is the first court. And ECCC is the first court to allow victims to participate in the procedure as full party. Victims are admitted as party at the ECCC. This is based on French system. So ECCC is the only international tribunal to allow parties to play the role, to allow victims to play the role as party. So almost same with the defense or the prosecutor. Same right to ask questions to the accused. Same right they can enjoy during the criminal procedure. That is ECCC. So for the ICTY, it has developed this procedure and the structural protection for the victims and witnesses. So victim and witness section for ICTY and witness support unit for ICTR, and they provide counseling, medical and psychological care and other appropriate assistance, and also requires some gender-sensitive approach in the appointment of staff. So they require many experts for this purpose. And also, the court can order appropriate measures to safeguard the privacy and security, especially for threatened witness or vulnerable witnesses, provided that they are consistent with the rights of the accused. So the most difficult part of the judge is to keep the balance between protection of the victims and respecting the right of the accused. How to keep the balance in specific cases, that is always very much difficult to do for judges. Same in national court and also international court. So such as expunging, removing names from public records, or having closed the session in camera, or testimony through audio-video devices, or testimony through closed-circuit TV. This can be done for the protection of the victims, especially women and children. And they also provide some special treatment over the evidence made by the victims. This is giving some strong power over the testimony or written statement of the victims. So, as I said, in many sexual crimes, the victim's testimony is the only evidence. So, if the evidence, the testimony is believable, then ICC do not require of corroboration. Some extra evidence to support victim's testimony is not required. Only one evidence of victim's testimony is enough to convict the accused. And in most of the sexual crimes cases, the defense always say that it was permitted by victims. We call it the victim's consent. But this is not allowed at ICTY, provided that the victim has been subjected to or threatened with or has had reason to fear violence, duress, detention, or psychological oppression, or someone else is in this situation. Then this victim's consent defense is not allowed. And even if allowed, the evidence on this regard should be satisfied the trial chamber in camera through in camera hearing. It's very much limited also. And victims' prior sexual conduct history is not admitted as evidence at the ICTY. So victim's testimony is very much strongly supported by the court. This is very much exceptional among the normal criminal procedure. So the international tribunal is taking good care of victims' testimony in the criminal procedure. This is the case of the ICTY because, as I said, the keeping balance between protection of the victim and respecting the rights of the accused is very much difficult decision to make. So, as you know, the cross-examination from the accused very much important in the court hearings. So, prosecutor asks questions to victim first, and then the lawyers of the accused ask questions again. That is cross-examination. But can we prevent the accused from having this cross-examination? That was the issue at the ICTY. So, at the Paddy case, the chamber, the judges, allowed non-disclosure of identity of the witness to the accused. So if the accused and lawyers do not know the identity of the victim, witness, then they cannot prepare cross-examination. So this is not allowing any cross-examination to the accused. But the court, the chamber admitted it, noting that fair trial means not only fair treatment to the defendant, but also to the prosecution and to the witnesses. That caused a huge debate especially from common law system, because common law system, cross-examination is the most important part of the criminal procedure. So if the chamber do not allow cross-examination to the accused, this is not admitted as fair and adversarial trial especially to the common law system. So it was not maintained. So at the next case, the Bransky case, they showed different opinions. So from the start of the trial, if the trial's hearing starts, the rights of the accused to an equitable trial must take precedence, and the veil of anonymity be lifted. So now all the cross-examination is always admitted at the ICTY and other international tribunals. So it's not easy thing to do. But like some experience at national court, we need to think about this approach. Not for the whole crimes, but we can limit it to some sexual crimes. So limit it to the sexual crimes, and under these very strong conditions, we can encourage the accused or lawyers to find another evidence to impeach the reliability of a victim's testimony. We still have room for that. So, still many common law lawyers may be upset about this, but I personally think that if this can be limited to sexual crimes, then we can think about this approach once again, maybe in the future. That is my personal opinion. And ICC is also almost similar with ICTY, but a little more advanced than ICTY. So even ICC requires some judges, ICC judges, with legal expertise on violence against women and children. So even they require this kind of expertise from judges. And similarly, victim and witness unit is providing the support for the victims. And also, court can order appropriate measures to protect the victim and witnesses. and especially for sexual or gender violence or violence against children, these protective measures, the proceeding in camera and testimony through electronic technology, is compulsory. It's not optional, it's compulsory. And the accused should prove that these are not necessary. So this is more advanced than ICTY. So it's not just option. When these sexual violence or children violation against children, these protective measures are necessary, compulsory. And ICC also put some more power on the evidence of sexual violences, like ICTY. So, and as I said, regarding ICTY, the victim's consent also cannot be inferred, cannot be presented during the criminal procedure, where victim's ability to give consent was undermined or incapable of giving genuine consent. And such procedure and the history of the victim cannot be presented to the court. So this is almost similar with ICTY. And as I said, ICC allows more participation of the victims, not as just witness, but also some more active participation during the criminal procedure, such as presenting views and concerns and requesting for reparation, as you know well. So these are the more participation at the ICC from the victims. And ECCC is also almost similar with other courts. We have some procedural and structural protection, almost same with ICTY and ICC. And as I said, we provide more active role for the victims. So as full participation in criminal proceedings. But to be admitted as a civil party, the victims needed to demonstrate that he or she was in fact suffered physical, material, psychological injury as a direct consequence of the crimes alleged against the charged person. So if these requirements are met, then victims admitted as a civil party and participate in the whole procedure as a party. So the lawyers representing the civil parties ask questions, even ask questions to the witnesses. That is this procedure. Now I'd like to make some proposals for the international human rights tribunals. Since the Second World War, many states have shared the necessity to develop some regional system to protect human rights while respecting domestic remedies by national government. So European states established the European Court of Human Rights in 1959 based on European Convention on Human Rights, and Inter-American Court of Human Rights, and also African Court on Human and People's Rights. But Asia is the only continent that does not have this kind of regional tribunal for human rights. And as I said, violation of human rights does not always amount to international crime. So many Asian people are still filing violation of human rights to the ICC. But ICC cannot accept it because it's not reaching international crime at all. So now, but why they send it to ICC? Because Asia does not have something like European Court of Human Rights. So if they cannot be satisfied with the national procedure, then Asian people cannot do anything at all. But given the immense population of Asia and fast economic growth of Asian states and great enthusiasm of Asian people, Asia could be leading power of world economy soon. And this power should be accompanied by the development of human rights and rule of law, especially for women and children. And during the discussion, Asian states can share their experiences and compare and even improve their own system. So if we just gather together, Asian states gather together and work together for the establishment of this court, the development of a domestic human rights protection system, and even eventually the development of protection of women and children can be followed, can be achieved, even during the negotiation for the establishment of this court. Because this is a very concrete goal. It's not just saying that let's develop human rights, but this concrete goal, establishment of Asian Court of Human Rights, can achieve other goals as well, even during the negotiation process. And this court should be established by the convention on Asian states, so something like Asian Convention on Human Rights. And the application should be allowed not only states, but also individuals, such as any person, NGOs, can file claims to the Asian Court of Human Rights. But still we need to respect the national systems. So the claims should be admissible only after exhaustion, only after trying all the domestic remedies. And the decision should be final and binding. But as I said, this is not criminal responsibility. This is state responsibility. That's why it's more easy to file. So the protection of women and children in international criminal procedure have been developed alongside with the progress of international criminal tribunals. And the establishment of international criminal tribunals has helped victims feel relieved, and also could achieve truth and reconciliation effect through court procedure, and also have helped the victims proceed to a better future through judgment. But I believe now it's time for Asia to also think about the establishment of Asian Court of Human Rights for further protection, for effective protection of the women and children rights of all Asia or Asia Pacific. Thank you very much.